Hello and welcome back to part 5 of this video on elementary logic for the first year BA LLB students 2024 from Mumbai University. So in this particular video, as per the syllabus provided by Mumbai University from module 1 1.4, today we are going to look at some of the basic logical concepts like truth, validity, inference, implication. What do they mean with their relevance in law and legal reasoning? So let's look at the truth. What is truth in logic and how it is related or what relevance it has to legal arguments? First, let's look at the definition of truth in logic. What is truth? In logic, truth refers to the property of a statement or proposition. I explained earlier what a proposition is. Proposition has a truth value, that is, either it is true or false. For example, I am 6 feet tall. It is either true or it is false. So that is a proposition. So in logic, truth refers to the property of a statement or proposition that corresponds to reality or facts. A statement is considered true if it accurately reflects the state of affairs it describes. As I explained earlier with an example, it is the same thing. Now let's look at truth versus validity in legal arguments. So truth pertains to the accuracy of the content of the premises or conclusions. So it basically means how true is the premise or the conclusion. The accuracy of that is the truth. For example, in a legal argument, the factual accuracy of evidence or claims such as witness testimony or documents determines whether the premises are true. Validity, on the other hand, refers to the logical structure of an argument. So, validity has nothing to do with the content of the argument. Rather, validity is concerned with the logical structure or the logical form of an argument. A valid argument is one where if the premises are true, the conclusion must also be true. But the premises themselves do not necessarily have to be true. This is very important to understand. I can say something about a moon. A moon is chocolate. I like chocolate. So I like moon. The form, the content may not be true, but the structure, the form is valid. I hope you understood. You can re-listen to this example again of the moon to understand what is valid. And validity, basically, just to recap, validity means validity of the structure, validity of the form of the argument, how the argument's structure is, whereas truth pertains to the content of the premises, how true the premises are, or what is the quality, the quantity of that truth, of that premise and conclusion. Let's move on to the relevance to legal arguments. In law, the distinction is crucial. Legal reasoning often focuses on the validity of the argument, that is, the logical structure, while also relying on the truth of the facts presented. For example, a lawyer might use valid reasoning to argue a case, but if the facts are untrue, the legal argument may fail, regardless of its logical structure. Next, let's look at the validity in logical arguments and legal reasoning. As I explained earlier, the validity is directly related with the structure or the form of the argument. So, definition of validity in logic. An argument is valid. An argument is valid if the structure of reasoning ensures that the conclusion follows logically from the premises. So, an argument is valid if the conclusion logically follows from the premises. This is the most important point, that the conclusion follows logically from the premises. The premises, when true, guarantee the truth of the conclusion. It's a common sense. If the premises are true, the conclusion will be true. Importantly, validity doesn't concern the actual truth of the premises, just the relationship between the premises and the conclusion. Validity doesn't concern the actual truth of the premises, just the relationship between the premises and the conclusion. Now, validity in deductive reasoning. In deductive reasoning, validity ensures that the conclusion necessarily follows from the premises. A valid argument is one where, assuming the premises are true, the conclusion must also be true. So, a valid argument is an argument where if we assume the premises are true, then the conclusion will also be true. For example, let's take an example. Premise 1, all suspects in a crime are to be questioned. Premise 2, the defendant is a suspect, so defendant must be questioned. It follows naturally. So you cut out the suspect, then the defendant must be questioned, to be questioned. The defendant is to be questioned for the crime. Relevance to legal reasoning. In legal reasoning, deductive reasoning is crucial for applying general legal principles, laws and precedents to specific cases. A valid argument ensures that legal principles are consistently and logically applied, even if the premises or the facts themselves are not universally true. I'll explain what is universal and what is particular. So when we say a statement all, when we use all, it is universal. So there are four ways in which the propositions are divided: A, E, I, O. A is all, universal. So this is universal positive or affirmative. E is no. This is also universal, but it is universal negative. It is universal negative. This is universal positive. I is some. Some are. And O is some are not. So basically what it means is we have this opposition of proposition square, which we'll study later on. It's a very, very beautiful thing, a beautiful chart, which we as in students of law should know this. So this states that all, let's take it with an example. All S R P. So this is the statement which A talks about, all S R P. Here this states no S R P. No SRP for this one, E. This states that no SRP. Here it states some S R P. Whereas this says, the O states some S are not P. So this is the four way which we can divide the propositions into A, E, I, O. All S are P. This is universal positive. This is called as universal negative or universal affirmative for the A. I is considered as particular positive, because it relates it to some, particular positive, and this is O is particular negative. I'm going little off tangent the topic, but just to make you understand what is here, we talked about universally true. So it is related with all suspects. So it is universal. Are to be questioned. So this is universal positive. So we'll cover this up later in the chapter of opposition of proposition. This is known as square table. So we'll look at it later on. So let's move on. A valid argument ensures that legal principles are consistently and logically applied, even if the premises or the facts themselves are not universally true. Example, a judge might use valid reasoning to apply a statute to a case even though the facts, premises in the case may differ slightly from other cases. Inference in logic and its role in legal decision making. So to make you understand quickly what inference is, I'll show you with a flow chart. So we have premise 1, premise, let's say premise 2, and then we have premise 3, and then we have conclusion. So when we have these three premises, the relationship between them is that of implication. Whereas the relationship between the premises and the conclusion, the process of coming to the conclusion from the given premises, is known as inference. Inference is a process of deriving a conclusion or drawing a conclusion from given premises P1, P2, P3. We infer or we reason, and then we come to a conclusion. So this is what inference is. So let's look at the definition of inference in logic. Inference is the process of drawing a conclusion, that is coming to a conclusion from premises, from these three premises or evidence. It is the mental step. It is thinking. It's a process of thinking that connects statements. This connects statements 1, 2, 3 and 4. Even conclusion is also a statement. Conclusion is also a proposition. So it connects statements or evidence to a conclusion. There are different types of inferences, such as inductive, which is probabilistic, which we saw earlier, and deductive, which is certain. So inferences are of two types, inductive and deductive. Inference in legal decision making. In the legal context, inference is central to judicial reasoning. So whenever the courts or the judges come to a conclusion, they are using inference from given facts. Facts could be probabilistic, facts could be certain. Courts often rely on inferences to determine facts, especially when direct evidence is not available. So if direct evidence is not there, then the court will infer based on certain facts. Judges and lawyers make inferences based on evidence presented to form logical conclusions. Example: if a defendant is found near a crime scene with stolen items, the court may infer that the defendant had knowledge of or was involved in the crime, even without direct evidence. So this is what is inference. If direct facts or facts are not available, direct evidence is not available, then the court will infer based on circumstantial evidence. Relevance to legal reasoning. Inferences are made from circumstantial evidence, witness testimonies, or precedents. Precedents are previous case laws, previous judgments. Lawyers may argue based on inferences, and judges will use them to interpret facts and laws in the case. Example: a lawyer might infer a defendant's intent based on their behavior, even if the defendant didn't explicitly state their intention. So even if the defendant doesn't say something explicitly, but if the lawyer can infer based on the defendant's behavior, how he behaved, based on that he can infer or come to a conclusion showing what the defendant's intention was. Implication in logic and its use in legal arguments. Implication I already explained here. It is the relationship between the premises, whereas inference is the relation between the premises and the conclusion. Implication in logic and its use in legal arguments. Let's look at the definition of implication in logic. Implication in logic refers to a relation between two statements where one statement logically follows from or is a consequence of the another. The statement, if P then Q, is an example of implication where Q is implied as a consequence of P. Implication in legal arguments. In law, implication refers to what is suggested or inferred from the language used in statutes, contracts, or precedents. In law, implication refers to what is suggested or inferred from the language used in statutes, contracts, and precedents. So when you read a statute or an act and when you come to some kind of conclusion from that, that itself is the implication, meaning we take the law, we read the laws, we read the statutes, we read the acts, and it implies something. So it is an implication. Legal reasoning often requires understanding implications that arise from the terms of a law, agreement, or previous contract decisions. So when you read a statement, for example, A is a father, that when you read that, let's say that is it, a sentence, a proposition, A is a father. Now what do we imply? What does that statement imply? It implies A is a man. Or we can also say, if he's a father, then A is a husband, because he is in a he is married, so he's a father. So all these things can be implied. It's an implication from that. Let's take an example. A contract may contain terms implying certain obligations, even if not explicitly stated. So that particular term may not state anything explicitly, but it is understood what it is, what that particular term or what that particular para of that agreement means. That is inbuilt, that's in the sentence, in the statement itself. Similarly, a law may imply certain rights or responsibilities even if they are not directly mentioned. So when you drive, it is to be taken that you will not break the signals. It is implied you will not break the signals, you will follow all traffic rules, and so on. So those, that doesn't need to be explicitly stated. Relevance to legal reasoning. Let's go into implication is critical in contract law, statutory interpretation, and tort law. Lawyers and judges rely on the implications of words, phrases, or legal doctrines to resolve disputes and determine the scope of legal rights and obligations. Application in judicial reasoning and decision making. Truth. Judges rely on the truth of facts, evidence presented during trials to make decisions. A legal argument can be valid but fail if the fact it rests upon are not true. Second, validity. Legal reasoning, especially in formal decision making, that is, example, applying statutes or precedents, requires valid arguments. Judges apply legal principles to facts in a way that ensures validity in their conclusions. Inference. Judges and lawyers make inferences from circumstantial evidence, witness testimony, and precedents. These inferences help bridge gaps in direct evidence and lead to reasoned conclusions. So whenever there is absence of direct evidence, the judges and the lawyers use inference or make inferences from circumstantial evidence, witness testimonies, and precedents. Implication. Legal arguments are often constructed based on the implications of laws or contracts. Judges interpret these implications to understand the full scope of legal obligations or rights that are not always explicitly stated. So that implies itself. Now let's go through some question and answers for our exam preparation. Question 1. What is the difference between truth and validity in legal reasoning? The truth refers to the accuracy of a statement in reflecting reality, while validity concerns with the logical structure of an argument. So truth is concerned with the accuracy of a statement, whether the statement is true or false. Whereas validity is concerned with the logical structure of an argument. An argument is valid if the conclusion follows logically from the premises, irrespective of whether the premises are true or not. Question 2. How does validity apply to legal reasoning? In legal reasoning, validity ensures that conclusions drawn from legal principles, example statute precedents, logically follow from the established facts of the case, It ensures consistency in legal application. Question 3. What is inference and how is it used in law? Inference is the process of drawing a conclusion from evidence or premises. In law, inferences help in establishing facts or drawing conclusions from circumstantial evidence or witness testimonies. Let's go through this question again. What is inference and how is it used in law? Inference is the process of drawing a conclusion from evidence or premises. This is what inference is. So it is a process of coming to a conclusion or drawing a conclusion from available evidence or premises. In law, inference helps in establishing facts or drawing conclusion from circumstantial evidence or witness testimonies. So inference could be both deductive inference and inductive inference. What is the role of implication in constructing legal arguments? Implications in legal arguments refers to what can be logically inferred from laws, contracts or precedents. So this is also very important. Implications in legal arguments refers to what can be logically inferred from laws, contracts or precedents. So if there is a law, what do we understand out of that law? That statute, that precedent, what do we understand? So whatever we can get out of that particular statute is implication, that it implies certain things. Those laws imply certain things. Lawyers and judges interpret these implications to understand the rights, obligations and consequences that may not be explicitly stated. So if certain things are not stated, then we can create an implication, or those things we can take out, it can imply, those statutes can imply certain statements or certain further premises although they are not explicitly stated. So as I gave an example earlier, I repeat again, A is a father. That itself means, that implies, there is an implication in that statement that A is a man. So if there is a, let's take an example of law. So A steals something. A steals something. So that itself means that A will be punished as per law. Whatever laws are applicable, he will be punished. How do judges use inference in legal decision making? Judges use inference to draw conclusions about the facts. So if facts are available, the conclusions will be drawn from the facts of a case. But if it is not available, then the inference will be drawn based on circumstantial evidence or pattern of behavior when direct evidence is lacking. Can an argument be valid but not true? Yes. A valid argument has a logical structure. So always understand what is validity. Validness and truth, there are two different things. A valid argument will have a logical structure or a form where the conclusion follows from the premises, but the premises may be false and the conclusion may therefore also be false. Why is truth important in legal arguments? Basically, truth is the content of that argument. So if the content of the argument is not true, then of course it will lead to an invalid, illogical, incorrect argument. Let's go through the question. Why is truth important in legal arguments? Truth is essential in legal arguments because the accuracy of the facts determines the legitimacy of legal conclusions. Even a logically valid argument may fail if it relies on false facts. So both are important. The truth, that is the content of the premises, the conclusion, and the conclusion will be false, of course, if the premises are false. But the content, the truth value of the content has to be there. Then the argument will also become valid. But the argument will fail if it relies on a false facts, that is the premises are untrue. How does implication affect contract interpretations? Implication helps determine the obligations or rights of the party in a contract by interpreting what is implied even if not explicitly stated. Certain things may not be explicitly stated, but it does not mean that those things are not there. It will still be there, it is implied, even though not stated. For example, in employment contracts, certain terms like duties may be implied from the nature of the job. Question 9. Explain the difference between deductive and inductive reasoning in terms of validity and truth. Deductive reasoning seeks validity by ensuring conclusion necessarily follows from the premises, whereas in inductive reasoning, on the other hand, aims for probable truth based on evidence, not logical necessity. Meaning, it does not need to be true. May not be necessarily true, but it could be probable. What role does validity play in judicial precedent? Judicial precedent rely on valid reasoning. Precedents are previous case laws or previous judgments which lawyers rely upon. So judicial precedents rely on valid reasoning to apply established legal principles to new cases. Courts must ensure that the application of precedents is logically valid for consistent legal decisions. So this is where we end right now. Thank you very much for your time and listening patiently till the end. I hope it helps you in your exams. Best of luck. Thank you very much. Keep listening and share it with your friends if it has helped you. Thank you.